Thank you, Mr. Speaker. I'm a litigator. And one of the things that we know is if you got the facts, pound the facts. If you got the law, pound the law. If you don't have either, pound that table. We got a lot of table pounding going on right in here. So I want to get it back to reality. Let's talk about the law. There are effectively three things that the law requires when you're redistricting state districts. The first thing is, does the Voting Rights Act apply? It does not. There's a three-part test to determine whether you are allowed to take race into consequence. We are not. Those three-part tests, in short, is this. Does the minority population vote together? Does the majority population vote together? And does the majority population vote together in that district in a way that stops the minority population from choosing their candidate? That is not true in any of the districts. So we're not allowed, as they've done before, to take race into consequence. So we didn't. We have the happy consequence, thankfully, that what we have done in not looking at those things is in making the districts much more compact. In Jefferson County, 30% more compact, more than 30% more compact. We have 4 minority-majority districts, 6 minority-majority districts, and 4 African-American minority districts. That doubles them. That's the happy consequence. But rule number 1 is the Voting Rights Act. Doesn't apply, but to the extent it would have, and it doesn't, but to the extent it would have, we complied with it. Rule number 2, one man, one vote. The United States Supreme Court, 60, 70 years ago, intervened with redistricting. And they said, no longer will we allow states to put 100,000 people in one district and 10,000 people in another. You have to make the populations of the districts similar. They started with the congressional maps, and they said you had to make them the same. And you'll see the congressional map that the Senate is addressing today, and we'll address on Saturday. There are 2 districts, I think, with 1 person that is different. So it's equal population. The United States Supreme Court said then, but when we're talking about local jurisdictions, states and counties and cities, you don't have to be equal population, but you got to be really close. We're going to allow you to take into the account things that your state thinks are important, but in no event may you go too far, and the too far is 10%. From the smallest to the largest can't be more than 10%. The Kentucky Supreme Court, in 5 opinions, Fisher 1, 2, 3, and 4, and in Jensen, then added on to that and said, we will allow you to go up or down 5%. In 2012, as well as in the 90s and the 80s and the 60s, the maps that the other party drew violated those rules and they were thrown out. This map adheres to the 5% up or down rule. The Speaker told all of us as we were drafting it, we will not have exceptions. We'll not try to have good faith exceptions. We will follow the law. This map stays within the plus or minus 5%, just math. The third rule is how many counties can you split? The Kentucky Constitution says you can't split any counties. But when the United States Supreme Court comes in and says populations, you have to have the one man, one vote rule, the Kentucky Constitution language is superseded. It's the supremacy clause of the United States Constitution, something that we all swore to a few days ago and last year when we were first sworn in. And it says, the Kentucky Supreme Court says, you can split counties, but you can only split the minimum number of counties possible within the plus or minus 5%. So we're giving you grace to go up or down 5%, but you can only split the minimum number of counties. 10 years ago, a number of people who spoke on this floor about this plan voted for a plan, and this is just math. They voted for a plan that they knew was unconstitutional because they were trying to protect majority members. This plan splits 23 counties, the minimum number that you can split. It hurts the majority party. If we were going to take power and just say all sheer power, we're doing what's best for us, we would split a 24th county. And in fact, it would only take 1 precinct. All we would need is 1 precinct in Nelson County, and we would not have some of our members run against each other. But the Speaker and our leadership said, we will not even come close to violating the law. Not even a precinct shall be split if the Kentucky Supreme Court says you can't do it. So we couldn't use that 1 precinct. My friend who I sit next to is losing a county because of 10 residents. 10. If 10 people didn't live in Fleming County that lived in Fleming County, he would keep his county. One precinct, 10 people. The Republicans have said, we will not even lean a little, because we are going to follow the law. And that's what these maps do in splitting 23 counties, but not 24, a precinct. So the 3 rules are complied with. But we know that the minority party hired a lawyer months ago before they've seen the maps. They've been having meetings over the summer talking about the potential lawsuit before they've seen the maps. That's fine, no problem with that. But they can't prevail. So what do? They come up with their own maps, and that's good. I'm glad they've done it. Welcome to the party, very late. Welcome to the party. When we asked them for maps before, they were non-contiguous, and only the Democrat members in Jefferson County, showing the seriousness with which they've approached this question. Unconstitutional on their face. Gentlemen from Davis, some of those precincts within Louisville, even within the Democrat areas, weren't even assigned. That's the seriousness with which this question was approached. Let me get back to the point. So we know the lawsuit's going to be filed, and what we've heard is there's a new plan. And it's very clear what happened. The lady from Jefferson 44 is a very, very smart and politically adept person. They're setting up a case for partisan gerrymandering. No doubt about it. That's what they're going to file. There's a problem, though. The United States Supreme Court in 2017, in a case from North Carolina, said clearly, there are no cases for partisan gerrymandering in federal courts. The United States Constitution doesn't recognize such a claim. It's not justiciable. So now they're going to go to the Kentucky Constitution. I don't blame them. That's already been tried. In 1997, the Kentucky Supreme Court was presented with the question that Tom Jensen, someone who we all, the ones who know him, love him, a gentleman from Laurel, served in this body and in the Senate and also as a circuit judge. He told the Supreme Court when Laurel County was cut up in the 90s, this was done for partisan reasons. It shouldn't be allowed. And the Supreme Court considered that, and here's what they said. There is a difference between what is perceived to be unfair and what is unconstitutional. Apportionment is primarily a political and legislative process. Our only role in this process is to ascertain whether a particular redistricting plan passes constitutional muster, not whether a better plan could be crafted. These plans are constitutional. We're going to run under these plans. I would submit that any lawyer that would challenge it, unless it's something I haven't seen, and I've been in this area of law for a long time, challenged the plan in 2012 and won the case. The only time I remember that the Supreme Court ruled, and I was the general counsel for the Supreme Court for many years, the only time I remember the Supreme Court ruled from the bench that it was unconstitutional. But I would submit that any lawyer that challenges this plan violates Rule 11. There's no legitimate claim. Supreme Court has knocked them all down. We followed them assiduously, not even moving 10 people or cutting one precinct. Now, I want to talk about, that's pounding the table because you don't have the law. I want to talk about pounding the table because you don't have the facts. I'm going to keep my remarks, and I can talk about each district. I could talk about how no precincts are split, contrary to what my friend, the gentleman from Kenton County, intimated. Not one. Hundreds have been split 10 years ago. Bowling Green has been split up for decades. Decades. I can go to every district if we want to go there. But I'm going to keep my remarks to the south end of Louisville because my friend, the gentleman from Jefferson 37, remarked to me, or said a second ago, that I said something I did not say yesterday. I did not call out an individual as being someone who's not doing a good job representing folks. I'm sure that the representatives that represent the South End call back their constituents and do what they can do. But I'm here to tell you, I represent Middletown, which is split, doesn't need to be split, been split for decades. J-Town split 4 times, 5 times before. I grew up in the South End. I grew up in the streets on Dixie Highway and Iroquois and Valley Station. And making Valley Village with north of Wyandotte or putting PRP with north of Shively, it ain't right. And it was done for one reason, because the South End votes Republican and the north side of those districts don't. And so the South End folks haven't been able to pick their party, the member they want to represent. They've split their neighborhoods. They've split their precincts for one reason. Look at the maps. All I asked my friends in the South End to do will be look at the maps that were drawn in 2012, where they snake up and down Dixie Highway, and look at them now. And I know that not every neighborhood can be put together. My friend, the gentleman from Jefferson 37, said he goes all the way to the Ohio River. Well, I'm here to tell you the people of Valley Station have more in common with the people in Fairdale and Okolona than they do the people of Highlands. Gentlemen, putting Valley Station with Wyandotte is no different than putting Corbin with San Francisco. Legislator in San Francisco might be doing a good job, but they got no business representing the people of Corbin. If the people of the South End want folks from Wyandotte representing them, we'll find that out. But they're entitled to have their neighborhoods intact, and that's what this plan does. And it has a consequence, a significant consequence. When the mayor of Louisville, all of Jefferson County, comes to my office, he's given me the road plan a number of times. Not a single road, not one was in the South End. Not one. So we've heard about the war on Louisville the last 10 years, and I'm going to close my remarks in just less than a minute. We've heard about the war on Louisville the last 10 years. There's no war on Louisville. There's a war on the suburbs in Louisville. They won't let us decide who we choose to pick up our garbage. They won't put a road out in the South End. And they won't let the South End folks decide who's going to represent them, snaking their districts north of Wyandotte and north of Shively to get what they want. This plan remedies all of that. This is a good plan. It's a constitutional plan. And in November 2022, this is the plan we'll be running under. Thank you, Mr. Speaker.